The Commercial Court has just handed down judgment in the case of SK Shipping and Capital Maritime after a 10-day trial. At first glance, the case might appear to be one which is of interest only to the most hardcore of shipping lawyers. The dispute between the parties arose under a time charter and concerned the ability of the chartered vessel to meet its consumption capabilities. Despite, though, this relatively unglamorous and niche backdrop, the case has given rise to several issues of general importance to contract lawyers. The essential facts are straightforward. The vessel in dispute was called the Sea Challenger. Its owner, SK Shipping, the claimant and my client in the dispute, took steps to charter it out in November 2016. In order to attract the interest of people in the market, details of the vessel's consumption capability were circulated to brokers. As a result of this, the defendant, Capital Maritime, expressed an interest in chartering the vessel. After a short negotiation, a 2-year charter was concluded. The charter contained a warranty in its standard form as to how much fuel the vessel would consume during the charter. The vessel was then delivered to the charter service in February 2017. Compared to the warranted levels, the vessel overconsumed bunkers. Capital Maritime complained about this. It accused SK of having misrepresented the vessel's consumption capability. Eventually, in October 2017, Capital purported to rescind the charter and to terminate it for repudiatory breach. SK contended in turn that this was unlawful and they sought damages for breach of charter. Now, the ensuing dispute gave rise to numerous issues. The judgment is over 100 pages long. A lot of these issues were confined to the particular facts of this case and have no wider significance. However, there were a number of issues which gave rise to difficult points of general importance on which there had been little, or in some cases no, previous judicial consideration. I'm going to touch on a few of those issues in this briefing today. The first such issue concerns the relevance of a reservation of rights when considering whether a party has affirmed a contract. Capital first accused SK of having misrepresented the vessel's consumption capabilities back in March 2017. However, they didn't purport to terminate or rescind the charter until October 2017. Now, between March and September, Capital continued to make use of the vessel, but all the time they did so reserving their rights in the correspondence. Then, in September-October, Capital stopped giving any orders to the vessel and instead repeatedly called upon SK to perform their obligations under the charter, again, all the while expressly reserving their rights. Now, in the circumstances, SK, for its part, obviously argued that Capital had affirmed the contract and lost the right to rescind it by not acting sooner and by exercising its rights under the charter. In response, Capital argued that they hadn't affirmed the charter because everything they had done under a reservation of rights. Thus, it was said by Capital, they had not unequivocally communicated to SK that they intended to keep the contract alive come what may. Now, in the judgment, the judge noted that there has been very little judicial consideration of the effect of a reservation of rights when considering whether or not a contract has been affirmed. The court concluded that a reservation of rights often will have the effect of preventing subsequent conduct from being treated as constituting an affirmation of the contract. This is particularly so when the subsequent conduct amounts to the innocent party either performing its own obligations under the contract or simply trying to obtain information from its counterparty. On the other hand, where the innocent party makes an unconditional demand for substantial contractual performance from the other side, then that conduct may be incompatible with any express reservation of rights. In such a scenario, the court effectively heard that actions truly will speak louder than words. The moral of the story on this particular issue is that whilst parties often add a reservation of rights as boilerplate text to their messages in this kind of context, and whilst the repeated use of these words tend to mean that they're overlooked or not given undue significance by the parties, you should ignore them at your peril, because a reservation of rights may indeed have the effect of preventing what would otherwise be regarded as an affirmation from being treated as such. The next issue I want to consider concerns the circumstances in which the court will exercise its discretion under Section 2.2 of the Misrepresentation Act 1967 to refuse to allow a representee to rescind a contract and to award damages in lieu of rescission. Now, on the facts of this case, Capital had purported to rescind the charter and had conducted itself accordingly. The result of that was that if the court refused to rescind the contract, that would mean that Capital's purported rescission was obviously ineffective, and therefore Capital would be in breach of the charter by having purported to rescind it and having walked away from the contract. Now, the question for the court is, was this something the court should take into account when deciding whether or not to exercise its discretion to award damages in lieu of rescission? This was a novel and difficult point on which there's been no consideration or guidance in any of the previous authorities. Now, the court decided the fact that refusing rescission might place the representee in breach of the contract was not something it should take into account when deciding whether to exercise its discretion to refuse rescission. This was essentially on two bases. Firstly, Section 2.2 of the Misrepresentation Act specifically states that the court should take into account the loss caused to the representee as a result of the misrepresentation, and that it should also take into account the loss that rescission would cause to the representor. But critically, it does not state that a relevant factor is the loss the representee will suffer if rescission is refused. Secondly, the court considered that rescission is, in most cases, not a self-help remedy. In other words, it's not a remedy that a party can exercise without the assistance of the courts. Therefore, any party that purports to rescind a contract and conducts itself accordingly does so at its peril. So the judgment makes it clear that even where a representee may justifiably believe that it has a right to rescind a contract, it should exercise extreme caution before doing so, as a court may subsequently decide to award damages in lieu, thereby putting the representee in repudiatory breach of contract. Now, these are just two of the issues of general importance that were addressed by the court. There were various other such points considered in the judgment, including what state of knowledge of the facts and of its rights a party must have before it can be taken to have affirmed a contract. There's also the question of what measure of damages are to be awarded in lieu of rescission. Again, this is a topic on which there's very little authority. A further issue of general importance is when, considering the enforceability of a guarantee under the Statute of Frauds 1677, documents signed by an intermediate broker can be relied on, and also what is the authority of an intermediate broker in such circumstances. Now, I've touched on these issues in the article that accompanies this briefing. If anyone listening to this has any queries relating to those, or indeed any of the matters raised by this case, please don't hesitate to drop me an email. I'd be glad to discuss them with you. Thank you very much for listening.